Having introduced the UN human rights system in general terms, I now want to move on to discuss the two main functions that it plays, and that in fact all protection mechanisms that we will talk about in the next few sessions do perform. That's on the one hand reporting, and on the other hand complaints mechanisms, and in particular individual complaints mechanisms. Now both of them are quite broad areas, and this is why I will introduce quite a few reporting mechanisms in this clip alone. However, I think it's a useful distinction to draw because it gives you a general idea, or it gives you a general orientation what human rights protection systems are about. And if you remember the public international law course last year, you of course covered monitoring, for example, quite extensively, and reporting procedures are basically one way of monitoring the compliance of states with their human rights obligations. States submit reports, thereby create information, and thereby give us a way or insights into where things can be improved, to put it mildly, or to put it more starkly, where there are violations of rights obligations. And these are actually already two of the advantages that can be flagged and that are the part of the answer to the first questions. Reporting mechanisms create information that's absolutely essential for the functioning of the human rights system. And they're also cooperative, so they give states the opportunity to genuinely improve. Not all human rights violations are necessarily made in bad faith. Sometimes they're capacity issues, sometimes they're awareness issues. And indeed, a reporting system, a system in which compliance and the areas in which improvements can be made are continuously illuminated, gives the possibility for such advances. That being said, it's worthwhile to look into the specifics of the various reporting procedures. And here, very much drawing on the previous video, I want to make a distinction between charter-based mechanisms on the one hand and treaty-based mechanisms on the other one. And in the chapter, of course, the discussion is similarly structured. Looking at the charter-based mechanisms, we have the Universal Periodic Review, which is in fact one of the main new innovations that came about with the Human Rights Council when it was created in 2006. And as the textbook rightly explains, the idea here is to create a peer review mechanism in which periodically, so continuously, reports are being provided and then assessed by the state parties, basically amongst one another. Each review cycle lasts 4.5 years, and all UN member states are being reviewed in this process. And this is, of course, both the reason for its name, Universal Periodic Review, as well as one of the main strengths, because here the reporting procedure does not in fact depend on a particular ratification of instruments. Even if a state had not ratified any instrument, and that's actually not the case, there is no such state in the world, there would still be customary law bases, the UDHR, general principles, which could be used by the states in this UPR review process. I won't describe the whole process, which is very well depicted in the book, but I do want to say that at the end of it, there stand recommendations. And of course, the continuous nature of these recommendations, the fact that every 4.5 years a state receives new ones, makes for a sort of gradual implementation framework that is indeed very useful if the expectation is not, as sometimes is the case in the human rights field, that there would be immediate compliance with all obligations. It's a work in progress, and we should also perceive it as such. The other leg of the charter-based reporting procedures are, of course, the special sessions and the special procedures. And both of them are, in fact, responses to either particular situations or particular issues. In the case of special sessions, it's when it comes to an urgent crisis, something that is happening and that requires an immediate attention, usually humanitarian disasters, armed conflict, sometimes environmental disasters, that then draw the attention of the Human Rights Council. And here, by means of fact-finding missions and general inquiries into the situation, information is being produced, again, in the form of reports that can then drive the agenda to restore human rights compliance. And the special procedures, of course, are most notably the special rapporteurs, and we covered that in the session when we talked about civil and political rights. If you remember the interview with the former UN Special Rapporteur on the prohibition of torture, Manfred Nowak, then you also remember that this is about country visits, reports, again scrutinizing the performance of states in particular areas and with regard to particular rights. Moving on to the treaty-based mechanisms, we have a sort of similar or comparable at least picture, though in this case, of course, with regards to each UN human rights instrument and each of the committees that come with such an instrument. So here states are firstly required to, upon joining, issue a initial report in order to basically clarify the overall situation. And after that, we also have periodic reports. These reports are then subjected to a review procedure in which the committee of experts that I talked about in the previous video goes through the various points that are there, also consults other information provided, for example, by NGOs. And then after a public hearing in which the situation is then basically scrutinized with a state delegate, comes to issue recommendations very much comparable to the ones that we also have in the UPR. The difference between the charter-based and the treaty-based system and the concluding observations in the latter is, of course, that they pertain more specifically to specific issues that are of concern to a particular committee and that relate to a specific treaty, such as, for example, the CRPD, the Convention on the Rights of Persons with Disabilities, or, for example, CEDAW, when it comes to the elimination of all forms of discrimination against women. You might ask now whether there is now overlap between, on the one hand, the reporting procedures in the charter-based mechanisms and in the treaty-based mechanisms, and of course even within the treaty-based mechanisms. And yes, that is the case, and that comes with advantages and disadvantages. On the positive side, a light is being shed continuously on various aspects, ranging from the rights of migrants to, of course, the implementation and progressive realization of social and economic rights. And this creates a sort of genuine cycle in which we know how a state is performing and we know what the challenges are. And this state is also being, based on this information, pressured to comply with the obligations. It's also universal, well, the universal periodic review anyway is, but even if we look at the multiplicity of treaty-based mechanisms taken together, they also cover all states on a variety of issues that are really creating a global system of human rights monitoring. But there are, of course, also downsides. It's a resource-intensive, labor-intensive process, and while many states, in particular developed states, don't have a problem to submit once in a while a report to a particular treaty mechanism or to the UPR, states that are smaller and that maybe lack the capacity can face real backlogs. And this, of course, is the reason why we have both simplified procedures and also review procedures that give poorer states in particular a means of complying with the reporting requirements, even if they're not able to submit all the reports on time. And finally, and this won't come as a surprise, these reporting procedures are often claimed to lack teeth, in the sense that it's not really an enforcement procedure as such. It's really states issuing reports and then getting basically a response or reaction to it, and that finishes in a way the process. To conclude, it is probably best to perceive those reporting procedures as one piece of the puzzle when it comes to human rights promotion. Yes, they're essential, they create information, they create the basis for further action, but they in and of themselves do not often create the pressure that is required to make progress per se. This concludes the second video. I'll now move on to discuss complaints procedures.